Welcome to Embedding Appellate Attorneys on Trial Teams. I'm Neil Wall, Secretary of the Beverly Hills Bar Association Barristers Young Attorney Section, and I'm delighted to introduce today's speaker, Kirk Jenkins. Kirk Jenkins is a partner at the law offices of Kirk C. Jenkins and a seasoned appellate attorney with nearly 40 years of experience in high-stakes litigation, particularly in federal preemption and constitutional law. He has handled complex cases and matters involving environmental contamination, product liability, and consumer class actions, consistently delivering successful outcomes through his deep legal knowledge and strategic approach. Known for his clarity in argument and leadership from trial through appeal, Kirk is a trusted advocate and respected authority in appellate practice. And now, let's get started.
Thank you, Nia, for that very generous introduction. My name, as Nia said, is Kirk Jenkins, and I'm an appellate specialist in Half Moon Bay. I've been an appellate specialist for the last 31 of my 39 years of practice. And as best I can figure, that is somewhere north of 300 appellate matters. And my task today is to convince you that you need to add a new senior lawyer to your trial team. At the outset of my career, back in the medieval times, our cases came about in what one might think of as the traditional way. We got the call after either an adverse judgment had come down or the opponent had filed a notice of appeal. Because, fun fact, messing up a notice of appeal, my first job was always to scrutinize it to make sure the other side hadn't messed it up. Because if you mess it up, that's one of the few things in California appellate practice that you can't fix. Those days are increasingly past history today as clients recognize that an embedded appellate lawyer is a wise and important value added on the trial team. Now, I know what you're thinking. How on earth am I going to persuade the client to allow me to add another senior lawyer to the trial team? Well, we all know that going to trial is terribly expensive, but not nearly as expensive as having to go to trial twice. And I'll have some statistics about that in just a moment. It also eliminates the expense of ramp-up time if the appellate lawyer was on the trial team. Appellate lawyers on the trial team started out in the insurance industry about 10 years ago, but from there it spread to big pharma, and most recently to more general corporate clients. Over the years, I've played the role probably 36 times. Appellate lawyers can be a matter of simple risk management in high dollar or bet the company cases. In complex statutory or regulatory cases, appellate specialists can offer expert guidance on preserving complex issues, and we'll get back to preservation in a minute. I've been in a ton of sophisticated constitutional cases in my career, and precision in briefing in these cases is absolutely critical. Finally, it's important to know when you're in a friendly circuit and mold your positions accordingly, or in a hostile district. Defending a corporate client in Texas versus defending one in California, or in the Fifth Circuit versus the Ninth Circuit, totally different deal. And trust me, there's a whole art form to representing insurance companies. A few examples for you. Tesla had appellate counsel on its trial team when it went to trial in the INRI Tesla Tesla Inc. securities litigation. The Harvard affirmative action case from a couple of years ago is another good example. In that case, both sides had embedded appellate counsel at the trial court level. The Federal Justice Department has embedded appellate counsel with trial teams routinely for years. Several U.S. attorneys' offices do too. Now, you have to begin with doing your due diligence, and you begin that by checking out the judge. A friend of mine was an appellate specialist in private practice, now as a trial judge in Los Angeles County. She's always delighted to see an appellate lawyer show up for trial. Take a look at the judge's rulings and the analytics on how she or he has fared on appeal. That data is everywhere today. Does the judge get reversed a lot? Then the reaction to seeing appellate counsel shows up becomes a tad more difficult to predict. On the other hand, if the judge gets affirmed a lot, she might be just fine with seeing appellate counsel in the courtroom. Does your judge show an academic bent? Are there case citations all over the judge's trial court rulings, or is it what we call Ipsy-Dixit law? Because I say so. The classic trial judge complaint about seeing an appellate lawyer show up was always, "You're here to get me reversed." I heard the perfect response to that in a CLE about embedded appellate attorneys just a couple of months ago. "No, Judge, I'm here to get you affirmed." Now, we need to keep an eye on an obvious point that we might otherwise overlook. What's your opponent doing? If the opposing party has an appellate lawyer on the trial team and you don't, you might be at a serious disadvantage if you don't go get yourself one. So always keep an eye on the other counsel table. So what about the trial lawyer? The relationship between trial and appellate lawyers has always been just a bit fraught. Now, I'm a big believer in staying in my lane. I have nothing but respect for trial lawyers. I did it for the first 8 years of my career, and you'll notice I don't do it anymore. The most important note, and put this in all caps in your notes, is if you're the appellate lawyer, you are not in charge. Trust me, if a corporate in-house lawyer gets the sense that the embedded appellate lawyer thinks they're in charge, they're going to be fired on the spot. I've heard in-house counsel who use embedded appellate counsel all the time publicly promise that in a panel discussion just a couple of months ago. The first chair trial lawyer is your client every bit as much as the client is. Listen to her, work with her, give her your best advice step by step. But if at the end of the day she decides to go another way, that's the trial lawyer's prerogative. The classic complaint about adding an appellate lawyer is, well, if he has trial lawyer partners, they'll poach the work if this matter gets reversed and sent back for retrial. Now, I hope I don't have to say this, but never, ever poach trial work from clients that you met in the course of your trial consulting practice. If you get a call from a client that you met that way, gently tell her no, and your next call is to your trial lawyer. Nobody can afford to shoot their practice in the foot like that. So where are you going to sit in court? I've had trial lawyers say they don't want the jury to think they're over-lawyering the case. So they think the appellate lawyer should sit in the back. Some of them even advise the appellate lawyer to dress in what today we call business casual rather than what you would ordinarily wear to try a case. I think, with all due respect to our trial lawyer clients, that this is a mistake. Very few cases are, how shall we put this, major draws for getting together a crowd. So it's not like the judge isn't going to notice that person in the back row madly scribbling in a legal pad all the time. I heard a war story not long ago of a lawyer who was told by the judge, "Counsel, if you're a lawyer in this case, you need to come forward and enter your appearance." And bang, you just shot yourself in the foot. Now, I talk about sitting in court. There is another alternative if your client is reluctant or the budget is short. Now, there's a lot of variation to this. I haven't run numbers on it. So some cases it may be a good bit cheaper. Some cases it may not be. But it is possible to make your embedded appellate attorney into a kind of office staff. That way, she or he can concentrate on writing briefs and motions during the day and review the daily transcripts every night. I don't particularly recommend this because you lose the advantage of your appellate lawyer warning you immediately to preserve something or get another bit of testimony in. but I have done it multiple times in my career, and it can work. The first slide, differing perspectives of trial and appellate attorneys. Consider the differing perspectives of trial and appellate lawyers. Trial lawyers are working in front of juries of lay people. Appellate attorneys are working in front of panels of 3 or sometimes even 7 judges. The question is different. And you can see that when a trial lawyer makes the mistake of coming to an appellate court and offering his jury argument. We appellate lawyers always say we can spot a trial lawyer at the Court of Appeal from a mile away. At trial, the issue is what is right and just. That's the trial lawyer's focus, and that's what the trial lawyer's focus should be. For the appellate lawyer, the question is whether there was error, not just mere error, but reversible error, error that potentially led to a different result on the merits. Appellate lawyers are always focused on the elements of the claim or the defense. My next slide talks about the attributes of appellate vision, the things that appellate lawyers spend their days thinking about. Appellate lawyers are always laser focused on the record. They focus on preservation. The saying among appellate lawyers is if it's not down in the reporter's transcript, it never happened. Now, I promised you a minute ago an example of that, and here it is. An amazing example from an article I found in J.D. Supra. Of course, preservation doctrine isn't new. What is new is how often it's becoming the central reason an appeal fails, and therefore a powerful reason to have an appellate lawyer on the trial team. Now, for the data nerds among us, the earliest example of this would be Trenier versus Stewart, 101 U.S. 797. But a quick test on Westlaw confirms the point. We search for fail within 3 of preserve in the same sentence as appellate within the same sentence as review, targeting opinions that address a failure to preserve an issue for appellate review. The result is 2,554 hits just from the federal courts of appeal. And if we apply a date filter, we discover that 251 of these decisions were issued just within the past 3 years. In other words, 10% of all federal appellate decisions addressing failures to preserve error since 1879 have come down in the last 36 months. That's not just noise. That's a signal of an increasingly cranky appellate bench squarely focused on the state of the record. Appellate lawyers worry about standards. How is this issue going to be reviewed on appeal? They focus on the elements of the claim or defense and whether there is harm. There is also a big picture aspect of appellate vision that can be valuable all around. The appellate lawyer typically hasn't been involved in discovery, although we are occasionally brought in for discovery motions. So she or he can focus on the truly salient points, cutting to the chase for the trial judge in a way that the appellate court will understand and appreciate. Let's talk about the areas where the appellate lawyer adds value during the trial, and that's my next slide. First, witness examinations. You need to spend the night before each key witness exam reviewing the examination outline with your trial lawyer client. The last thing you need is for the appellate lawyer to obviously be stroking out over at counsel table when the trial lawyer asks a question that plants error in the record. You need to discuss these points the night before and have those conversations. Second, critical motions. Motions in limine can frequently be the whole ball game. What gets in trial and what doesn't. Now, they're an interesting problem once you go up on appeal since most of the evidentiary decisions are going to be abuse of discretion review. And listen very carefully to the ruling on a motion in limine. Very often, a trial judge will say something like, "We'll wait and see how it comes in." The appellate lawyer's eyes are going to light up when he or she hears that, because at that point, you definitely have to renew your motion in order to preserve the point. And in some jurisdictions, it's even worse than that. You have to renew all the evidentiary motions to preserve your objections. The motion in limine alone isn't enough. Discovery motions are much the same way. What that means is you probably need to win at the trial court. There are about 1 million citations for the proposition that we disagree with the trial court is not a valid reason to find an abuse of discretion. And it's certainly true that reversals for abuse of discretion are rare. One of my proudest moments was when I took the presiding judge of the district court up on 4 abuse of discretion issues and got him reversed on all 4. So it is possible, but that doesn't mean it's something you can rely on. And there's some good news here too. A lot of people don't spend much time pondering the standard of review, but it's something that appellate lawyers live and die by. It's not much more than cut and pasted from the last brief, but it's possible to make up some ground here. I remember arguing a case in San Francisco about 5 years ago. I began my argument, and the presiding justice, wearing what looked suspiciously like a "you're new at this, aren't you" look, said, "And what's the standard of review for that?" I explained that the court needed to address the standard of review in 2 steps. At the core of the question was a legal issue, and that's de novo review. Only after the court had resolved the legal issue, one way or the other, can you then take on the overall issue, which is reviewed for abuse of discretion. I was pleased to see that in the final opinion, the court agreed with me, and it made an easier road for us on appeal. Interim appellate interventions. This is another area where you need an experienced appellate lawyer, because different states have very different attitudes towards interlocutory appellate relief. In the federal courts, it's virtually impossible to get. Trial lawyers think it's easy in the California state courts. When you're ramping up to trial or in the middle of trial, everything that you lose, it's even money. Somebody's going to say, "Can we take a writ on it?" The fact is, it's a good bit more difficult than you might think. To understand whether a court is likely to intervene, the primary question is whether the court is likely to think this will all come out in the wash, or will be able to address the question more thoroughly after the record has been developed more. These are the kinds of issues that block most writ petitions and lead to those postcard denials that we've all heard about. Now, we talked a minute ago about the need to determine whether interim appellate relief is even possible. But there are all kinds of traps for the unwary scattered across the landscape here. First is the problem of statutory writ petitions. They're mostly a creature of California state law, but you need to have somebody on the team that knows those deadlines, because the deadline to file, and mind you, these deadlines are almost always jurisdictional, tend to be really short. So what about injunctions? That's another one. You have a client gets an injunction pointed their way, they're gonna want to take it up to the appellate court. So it's easy when you lose a money judgment, you just put up an appellate bond. How do you get out from under an injunction while you go up to the appellate court in the middle of a trial? The answer depends on whether the injunction is classified as mandatory or prohibitory, which means, does the injunction maintain the status quo, or does it require affirmative action? Now, you may hear that and think that's a fairly simple issue to figure out, Well, let me tell you, I've been involved in appeals that lasted 2 years that entirely revolved around the question of whether the injunction at issue was mandatory or prohibitory. So, no, it's far from simple to figure out. Other issues, collateral orders. Most trial lawyers haven't had to think about collateral orders since bar review, but you need to recognize them when you see them so you can alert your trial team that, hey, we can take this up right away. And the thing is, if it's a collateral order and therefore appealable immediately, and you don't appeal it, you just waived it. And there's also such a thing as statutory interlocutory appeals to make it even more complicated. Now, 1292B appeals, 28 U.S. Code 1292B. I practiced appellate law for 12 years in Chicago, and let me tell you, 1292B appeals were the bane of our existence. You read the statute, and it's attached to the materials for this webinar, and it sounds like the only function of the petition is a plain vanilla, please let me get into the queue and appeal this. Outside of the Seventh Circuit, that's what even federal appellate specialists think it is. But here's the thing. There are several judges in the Seventh Circuit who have the nasty habit of summarily deciding appeals based just on the petition. Several years ago, I had an antitrust case in the Seventh Circuit. The opponent, I won't name him, but he was a well-known appellate specialist, but not a Seventh Circuit appellate specialist. He filed one of those plain vanilla petitions, just let me in line. And I remember thinking, you may live to regret that. And sure enough, the circuit puts out a decision ripping the guts out of a 9-figure antitrust claim based solely on that petition. Now, of course, opposing counsel went bananas. Finally, the Seventh Circuit said, yeah, okay, whatever, and took the decision down and scheduled oral argument. Well, I was present at the oral argument, and I counted, and the same judge, the author of the decision that had been posted and then taken down, asked 57 questions in 30 minutes of this poor guy. And of course, a few days later, the court entered an opinion that looked an awful lot like what they'd put out a couple of months earlier. The moral of our story, of course, the house always wins. There are other more obscure appellate options that you need to have on your menu as you approach trial. If you're facing a putative class action, you need to distinguish between mandatory appeals under the Class Action Fairness Act, or whether we're going to have to resort to a discretionary appeal under 28 U.S. Code 1453. Now, the Class Action Fairness Act, I've done several appeals under that, and we could easily fill the entire hour on that subject. Basically, under 1447D, many remand decisions are simply not reviewable at the Court of Appeal level, but not all. The rule has exceptions to it. One exception is the Class Action Fairness Act. Basically, CAFA, as it's universally known, establishes a system of minimal diversity, a $5 million amount in controversy, and at least 100 plaintiffs, and you can go straight to federal court. 28 U.S. Code 1453C provides that notwithstanding 1447D, aggrieved litigants can petition a court of appeals for permission to appeal an order remanding a case that was removed under CAFA. Moreover, 1447D does not apply to all remands. The Supreme Court has held that it must be read in the context of the rest of the statute. And the Supreme Court held in Thermtron Products versus Hermansdorfer that 1447D applies only to remands authorized by the neighboring 1447C. 1447C authorizes remands due to a lack of subject matter jurisdiction or a procedural defect in the removal. So if a district court remands an action for any other reason, you're good to go. You can take it directly up. And so long as the remand marked the end of the action, the remand can automatically be reviewed under 1291. There's a whole host of pretrial motions that, and you can go to the next slide there. There's a whole host of pretrial motions that you have to give consideration to before you approach your trial date. Demurrers are governed in California State Court by Rule 3.1320. The party must file and serve a notice of hearing on the demurrer. Then there are motions to strike. These are governed by Rule 3.1322. And the notice of motion must be given within the time allowed to plead. Amended pleadings are another thing you have to think about. Increasingly, you have to think about motions challenging personal jurisdiction, because purposeful availment that we all remember from bar review has gotten tighter than it's ever been before. And personal jurisdiction over corporate clients in particular is tighter in the federal courts than it has ever been. So you need to take a very hard look at what the connections between your client and the state of California, if that's where you are, and whether they're direct enough to constitute purposeful availment, because there's a gigantic body of law on what does and does not constitute purposeful availment. Motions for change of venue are another big area. Are you better off in a different district or circuit? Do you have grounds to move? After denial of the motion to transfer, you get an automatic 30 calendar days under Rule 3.1326 to file your motion for change of venue. The final motion that we want to review here is motions concerning arbitration. And today they are everywhere. They're becoming increasingly important as we move forward. Caseloads in the appellate courts have consistently been falling in recent years, and most judges I talk to attribute the change to arbitration and the Federal Arbitration Act. Well, the rule governing arbitrations and motions is 3.1330. Daubert motions, as we review the motion list. Daubert motions are another turning point in your case. I was the embedded appellate attorney, or actually I should say I was the embedded civil appellate attorney, since I had a colleague who was a criminal appellate specialist in an antitrust case that went on for years. Because in my previous life as an economist, I was handling all the economic experts. We fought out multiple Daubert motions over the course of a number of weeks. I successfully saw a game theorist through the Daubert process. I thought the opposing economist was ignoring the principle that correlation does not equal causation. So I found this article arguing that just because shark sightings and ice cream prices both rise in the summertime doesn't mean one causes the other. I told the judge that the opposing economist's analysis was nothing but sharks and ice cream. My co-counsel thought it was hilarious. Offers of proof. Say the trial court excludes some of your evidence. You need the appellate lawyer to prepare an offer of proof showing what the evidence would have proven, and more importantly, how it's crucial to your case. Next slide, please. The thematic double check. What I'm talking about there is what I mentioned a few moments ago, the idea that you have to be very much aware of what jurisdiction you're in and be prepared to pitch your case in a different way, depending on exactly what the inclinations of the district or the state and the law in the state is. Next slide. We have been through all of those. So next slide. Daubert, motions in limine, preparing trial briefs. Preparing trial briefs is another crucial job of where the appellate lawyer can be helpful, because you can demonstrate to both the trial judge and, just as importantly, to the opposing party, that you have preserved all your issues and are ready to go up on appeal if you need to be. Phrasing of offers and objections. As I'll say, repeat in a moment, you have to be very sure that all of the offers of proof have been followed up on and all of the objections have been ruled on. Next slide, please. Let's talk about the hard part, daily trial reports. For the lead trial lawyer, this is going to be one of the primary barriers to your being the embedded appellate attorney on the team. They're going to think, oh, well, you're just going to rat me out to the client. But remember this. In my experience, most criticisms are actually confessions. And it's certainly true when you're talking about the embedded appellate attorney and the trial lawyer. I don't think we preserved this issue. Well, that's on you. We didn't provide all the necessary parts of the defense. Well, that's also on you. I'm not aware of many issues that you could conceivably complain about that aren't your failure as the appellate lawyer. But one of the main jobs for the embedded appellate attorney, tracking the evolution of potential issues for appeal. Do you have substantial evidence in the record for all of the elements of the claim or defense? If it's a point that you've already lost, take a clear-eyed look at whether you've got enough to argue at the Court of Appeal that the error was prejudicial, that harmed your case. And just as importantly, where are you about possible settlement of the case? The appellate attorney aids in determining where your case stands on that issue. The focus of the appellate lawyer is always on the status of error. You have to be consulting with your lead trial lawyer every night. What do you plan to ask the witnesses tomorrow? We've all had our moments where we had to tell the trial lawyer, no, you can't ask them that. Why? Because it'll get us reversed. That's why. Next slide. The name of the game is making sure all your objections are made and all the necessary motions have been renewed. You need to be sure that the judge has actually ruled on all the objections, because it's just routine for some points never to be ruled on. You also have to track all, and I mean every single one of the exhibits. Make sure each has been either definitively admitted or excluded. The same thing goes for your evidentiary rulings. You need to be very certain that every single one of them has been ruled on. Jury instructions and verdict forms are incredibly important for the appellate lawyer. Jury instructions are about parsing out the elements of the claims, the elements of the defenses, and making sure in the verdict form that every one of them has been decided one way or the other. Many trial lawyers will be tempted to capture the entire story of the case in a single instruction that goes on for pages and pages. This is a critical mistake. In nearly every jurisdiction, a trial judge is permitted to reject an instruction that's erroneous in any detail. And appellate lawyers are immersed in the details from State Farm v. Campbell and BMW v. Gore on how punitive damages need to be instructed on. The appellate lawyer needs to understand and keep in mind whether something has gone wrong during the case. Does there need to be curative instructions or limiting instructions? Pay attention to whether something came in for a limited purpose only, and make sure you've locked that down in the instructions. And here, I believe we can move on to the next slide. Sorry, mistrial motions are also a very important one that I should have noted as I went by. Here's one of the most important contributions of the appellate lawyer. You're going to get hit by something you weren't expecting. If you're up against a good tactician, she's going to notice when you've got 10 other things to worry about, and she's going to trot out a motion from left field for you to grapple with. That's what your appellate lawyer is for. Among appellate lawyers, we've all heard the objection, you can't do this or that because you're going to turn the trial judge against us. Well, that's an important function of the embedded appellate attorney. The trial judge needs to be very clear on what your function is and that you are not part of the trial team, strictly speaking, because then your job can be to be the buffer between the trial counsel and the judge. Don't hate my trial counsel, focus on me. The state of the record is absolutely crucial from the viewpoint of the appellate lawyer. And we can go to the next slide. The most frequent single question, where is the court reporter? Remember, if it's not in the reporter's transcript, it never happened. Trial lawyers will frequently think, well, I don't want to annoy the trial judge. Well, that's what you have your appellate lawyer for. Everything must be transcribed. Sidebars, in-chambers discussions, visuals by experts, videotape deposition testimony, juror questions, all of it. Every appellate lawyer I know has had the experience of getting a transcript for a case they weren't on at the trial level or they weren't the embedded appellate attorney, finding error, and then realizing they don't have enough in the record to make the case. One of the primary jobs of the embedded appellate attorney, you must carefully review all daily transcripts as the trial continues. It's your job to ensure that sufficient evidence is admitted on every key point. I believe we can move on to the next slide. And also, as this slide points out, you need to identify points as you go on which you need additional testimony. When the jury comes back, you're going to need to poll them. The juror verdict form. This is an incredibly important contact point. As an appellate lawyer, you have to review it in a very big hurry. Is it internally inconsistent? Have they made two findings that cannot be reconciled with each other? Because if it's not internally consistent, you have to object right now before the jury is allowed to go on their way. Otherwise, you've waived the point. Juror interviews. My last note on this slide. Candidly, everyone wants them, and they are nearly always a waste of time. There is a very narrow range of issues that can be heard on post-trial motions on juror interviews. Next is a crucial point that I think it's fair to say only appellate lawyers think of. And that is, if your client is the defendant or the cross-defendant, when you get to the point of submitting the case to the jury, you have to start thinking about the appeal bond. You have to ask the hard questions about your client's financial situation. The time you can halt execution without the bond is very, very short, typically as little as 10 days. And you're going to have about a day to get that motion on file. And appellate lawyers will have a Rolodex or whatever has replaced Rolodexes these days, full of numbers to call to find people who can provide the appellate bond for the client in about 24 hours. And your client is going to want to know two things. First, how long is my money going to be tied up? And second, how quickly are the interest charges going to build up? So your appellate lawyer is the person that's going to need to know all of those at the tip of the tongue. It can matter a lot how long the appeal is likely to take for this exact reason. Now let's talk post-trial motions, which I believe is go back one if you can. I think we skipped one there. Now let's talk post-trial motions. In California, Rule 3.1600 says that counsel must file a memorandum in support of a motion for new trial within 10 days of filing the notice of intention to move for a new trial. Particularly on the federal level, some motions need to be renewed in order to preserve them for review on appeal. As soon as all your evidence on a particular point has been put in, you make your motion for judgment as a matter of law pursuant to Rule 50A. Now, you're not going to win that motion, but the reason you make it is so you can renew the motion after the jury comes back. If you didn't make it to start with, you can't renew it. And you're limited to the issues that you put in that motion when you made it at the close of all of your case. If you didn't move for judgment as a matter of law under Rule 50A, you can't renew the motion under 50B. However, the good news is you can also make a motion for a new trial under Federal Rule 59, and those aren't limited by the scope of your earlier motion for judgment as a matter of law. If you get a shocking damages award, you'll need your appellate lawyer to prepare a motion for remittitor. These days are typically on punitive damages awards, which almost always will bring a motion for remittitor. It's a long shot, but you'll also be considering a motion for relief from the judgment under Rule 60. And here's an important point that I make on either this slide or the next one. Some verdicts can be successfully attacked in post-trial motions, making an appeal unnecessary. That's particularly true of punitive damages awards. You read all the time about punitive damages awards that are massively sliced in post-trial motions. And in the majority of those cases, ultimately there isn't an appeal. Once again, the issue is, where is the law going to be in 1 to 2 years, not where it is now. You must monitor cases which are currently in progress, so you know how the law in your jurisdiction is likely to change. Excuse me, you can go to the next slide. Okay, this is some of the big picture items that we discussed earlier in the presentation. It is possible to lose the game in the first inning. The appellate lawyers are kind of thought of as the academic on the team, worrying about the rules, worrying about the elements of the claim or defense, and worrying about deflecting blame. You can move on to the next slide. Okay, this is the issue that I was talking about. The appellate strategist has to know where the appellate lag time is increasing in your area, because that determines when the opinion is likely to come down. In California, if you file a notice of appeal today, you're not going to have an opinion for 2 to 3 years, depending on the district you're in. Um, so it's crucial that you monitor cases in progress in the geographical area where you are, so you're in a position to warn the trial team so they can take advantage of brand new precedent. You're going to be reading a lot of the daily notices of the new decisions coming down. One of the most important tools when the law is underdeveloped, the strategic amicus brief, and I think that's the next slide. Yes, I talked about CAFA and personal jurisdiction earlier, but the rest of these issues. The strategic amicus brief. First, what is your jurisdiction's attitude towards amicus briefs? Because believe it or not, they can be very, very different. Illinois, for example, where I practiced for many years, is very restrictive towards amicus briefs. Illinois, both in state court and in the Seventh Circuit, excuse me, Judge Posner issued a couple of chambers opinions about 20 years ago, in which he flatly said, this is not a show of hands, and set out a 7-point test that you need to be able to meet. And if you can't demonstrate that you meet those 7 points, he said, we don't want it. You're only burdening the court. And the Illinois state appellate courts have adopted basically the same test. So it is virtually impossible to get amicus briefs in Illinois courts. I had a big workers' compensation case there many years ago that I somehow managed to keep, I think it was 8 Fortune 500 corporations on a single amicus brief. And you talk about herding cats. One of the most important tools when the law is underdeveloped, the strategic amicus briefs. California accepts almost all of them. The only way that you can get an amicus brief turned down, particularly in the California Supreme Court, is if you're, shall we say, new around here and wait to submit it until a week before the oral argument when the case has actually already been decided. As long as you submit it during the briefing process, they're going to take it. And that's been true for at least 40 or 50 years. In California, moderately often, the state Supreme Court will actually allow an amicus to participate in oral argument. Let me tell you, that would never, ever happen in Illinois. But I see it fairly often in California. You admittedly have to have a fairly close relationship with one of the parties, and because you're going to have to divide your time, and a well-developed argument for why relief that will benefit that party will get you what you need. But it does happen fairly frequently. One of the crucial contributions that you can make as an amicus author is educating the appellate court on the realities of the industry that you're working in. Also, you can discuss the policy implications of the decision and set out the legislative history of the matter. I talk at the end of this, excuse me, slide about staving off the Thelma and Louise case. That's what that means, is the case where the opposing party is bent on betting it all on the result of the case, shove everything to the center of the table kind of situation. And you want to, through your amicus brief, make the argument that this was actually a very fact-driven situation, meaning that it's not going to be a good vehicle for anybody to make a broad sweeping pronouncement of what the law is in any area. Now, I believe this is the next slide. At times, your appeal will wind up in appellate mediation. There are still many things you can accomplish here. Don't hesitate to hand your brief to the other side. I've done it a number of times. Basically, this is what I'm going to do to you if we go to briefing. It's persuading the opponent that the appeal is a gamble. The Ninth Circuit's a gamble or a waste of money. Review carefully the districts or circuits you can target and figure out where you want to go. The Ninth Circuit's program, the Ninth Circuit mediators are very, very good, and you can frequently get cases resolved in the Ninth Circuit. The California Court of Appeal, it varies somewhat from one district to the next, but I've had a lot of good results over the years in appellate mediation. I talked a moment ago about balancing conflicting decisions from different districts. Review carefully the districts or circuits you can target and figure out where you want to go. If you get an adverse result from one circuit, balance it with a positive result from another circuit, and then you're in business because you can ask the Supreme Court to resolve the conflict. Excuse me again. Now we've got a little bit of time for questions before we wrap up. So I will.
Alrighty, so it does look like we have a bit more time for questions. Do you have any closing statements or pointers that you would like to provide for our audience while we wait for questions to come in?
Well, it's been a pleasure being with you. And as you can see, my email and phone number are at the end of the handouts. So you should certainly feel free to call, email, or text anytime you have something I can help you with. But the bottom line of this entire discussion to me is preservation is all important. Remember those statistics that I talked about with the number of cases, the number of cases that fail because of failure to preserve the issue. Trial lawyers can't be expected to think of everything. They have enough on their plate, and you need to have the academic on the team who is laser focused on the state of the record at all times and making sure Xing off everything that goes through as it gets preserved, because there's nothing worse than reaching the Court of Appeal and finding that you have issues that you could have made out, but they're not properly preserved in the record.
All right, perfect. We do have a few questions now rolling in. Giacomo Russo asks, do you find big law folks are more formidable than boutique firms?
Actually, in my experience, the opposite. I have been opposed both types of firms over the years. I've been in big law firms for the last several years, but some of the finest appellate lawyers in the state of California are in very, very small firms. The Horvitz firm, they're all very fine appellate lawyers. The Greenis Martin firm, California appellate litigation group, the people that I see on the opposing counsel list and think, okay, got to get the A game on this time, are the people from the small boutique firms.
All right, perfect. And we have a question from Sheila Pendergast asking, how do you delicately handle strategic conflicts with your trial counsel?
You have to make sure she understands exactly. Basically, the answer is you have to treat them like a client. You have to understand exactly what the decision involves, what the risks are, what the best case scenario is, what the worst case scenario is, and then at the end of the day, as I said in the presentation, you're not in charge. So if the appellate lawyer recommends something and fully explains, this is what we're risking, this is the worst case scenario, this is the best case scenario, at that point, it's up to the trial lawyer. And I have absolutely had that experience of ways that I recommended that certain things be handled, that the trial lawyer has gone another way, and it's absolutely no different than when it happens with a client, because they're your client too.
Great. And we have another question. How do you balance the appellate attorney's focus on preservation and the trial team's focus on persuasion?
The answer is you do have to balance them. You have to. I hesitate to use the phrase "walk and chew gum" because it sounds condescending, but there are times, for example, when you're in in chambers conference, the trial judge has to understand when you come back out, you have to enter a description of it into the record so that it'll be there in the reporter's transcript. Preservation, you have to preserve every possible error, because there is nothing worse than getting to the Court of Appeal and recognizing that something wasn't properly preserved. But at the end of the day, once again, it's the same theme. The trial lawyer is in charge. The appellate lawyer isn't. So if I have also had that experience of telling the trial lawyer, I think it's dubious whether we preserve this or not. And at the end of the day, it's his or her decision.
All right, great. And it looks like we have two more questions right now. Christian Dale asks, if a motion for reconsideration is filed first, can any new evidence presented to the judge at that stage be utilized on appeal?
I would think the answer would be it would be very difficult to get it in. That I think the record is probably frozen at that point. So my answer would be probably not.
Okay, and Marie Wrighton asks, presume you timely object that there is an inconsistent verdict before the jury is discharged. What happens next at the trial court level?
Jury gets sent back to consider further. The judge explains your answer to question 1B and 1C can't both be right. So I need you to go back and figure out which one you want to stand by.
All right, and what would you say are the most overlooked post-trial motions or steps that can affect appealability or preservation of issues?
Things like motion for new trial are the easy ones, but in the federal court, renewing motion for judgment as a matter of law is one of the crucial ones. As I said during the presentation, challenges to personal jurisdiction are becoming very, very, very important. And there are specialists out there in that area of law, because there is so much of it. What constitutes purposeful availment and what doesn't. So there are a lot of them is the answer.
All righty, well, it looks like we don't have any more questions. So thank you so much, Kirk, for your time today. And thank you so much for our audience. I wish you a lovely afternoon.
Pleasure being with you.